we're live, Mr. Wade. Good night, Belizeans at home and abroad. This is the Belizean Affairs Show number 235. 235. My name is Leonard Brackett. I'm the host for tonight's program on Fridays, mostly. I'll be your chairman, and we have two of our other uh, co-hosts. Mr. Roody Wade is with us right now, and somewhere in the background, I think our chief engineer as well, Mr. Gregory Brackett, and our next senior host may be doing some work. So he is going to show up when he's able to, and as soon as he gets his stuff together. Uh, Thank you very much for tuning in with us tonight. Those of you who are going to listen to the show live, and thank you also those of you who will be listening to it at your own convenience. We have been getting quite a bit of good ratings recently. People are becoming accustomed to us being available at the time that we say we're going to show up, and we just hope that we show up on time. But even if we don't show up on time, sometimes we may be a little late for whatever reason. We're still going to show up, and we're going to do what we need to do in terms of advocating on behalf of our country and people of Belize. I
Amen.
therefore wish to ask if you allow, if you'll indulge me in bow my head and say a short prayer, after which I'll turn over to Mr. Wade for the reading for a prayer. Divine loving Father, thou art our Creator, and the Creator of heaven and earth and all that in them is and are. Into thy hands we commend ourselves once more, asking that thou would continue to guide and protect and bless us, that thou would continue to be merciful unto us, that thou would continue to bless our country of Belize, its people and leadership, that thou would continue to bless this country of the United States, its people and leadership as well. We pray that thou must continue to bless the rest of humanity, Lord. Bless our hearts, our desires, even our most secret thoughts. Let the words of our mouth and the meditation of our minds and hearts be acceptable before thy divine presence, now and always. For we ask these mercies in Jesus' name. Amen.
Amen.
I turn over, I yield to you, Mr. Wade.
Thank you. Thank you, Mr. Chairman. It's always a pleasure, as always, to sit in your company. And
Pleasure is mine too, sir.
we give thanks to the Almighty for giving us this privilege
Amen.
to be able to, like you say, advocate for our people and country. Um, Again, welcome our viewers, both at home and abroad, to our 235th edition of Belizean Affairs. Yes, gotta. It was, you know, stay with that energy, and so it reflects in the new year, there, Mr. Chairman.
Looking forward to it, sir.
Yes, yes. May the new year bring us more closer, and you know, bring us, you know, good life, good
Yes, sir.
life,
May the new
and
year
bring
bring us,
us
may the new
many
year bring us,
blessings.
may the new year bring us uh, a change of heart and minds of our Belizean, our Belize
Oh
country
yes,
leadership,
oh yeah,
whether it be PUP, UDP, or NP, whichever
yes,
turns out to be. I
yes.
hope that we end up with a change of heart and a change of mind, and that the public and the people of the country derive the necessary benefits that we're duly entitled to. Thank you for letting me put that in on your
Amen,
commentary, sir.
amen, amen to that. That hit the nail right on the head, man. That's exactly what we look forward to. Um, Mr. Chairman, I will. You want to say something there,
No, sir,
Leonard?
no, sir, no, sir.
Okay,
I was
Mr.
listening.
Chairman, I want to do a reading from Proverbs chapter 28, 1 to 10. It reads, "The wicked flee when no one
Sweet.
pursues,
Amen.
but the righteous are bold as a lion. When a land transgresses, it has many rulers. But with a man of understanding and knowledge, its stability will long continue.
Amen.
A poor man who oppresses the poor is a beating rain that leaves no food. Those who forsake the law praise the wicked, but those who keep the law strives against them.
Amen.
Evil men do not understand justice, but those who seek the Lord understand it completely.
Amen.
Better is a poor man who walks in his integrity than a rich man who is crooked in his ways. The one who keeps the law is a son with understanding, but a companion of gluttons shames his father. Whoever multiplies his wealth by interest and profit gathers it for him who is generous to the poor. If one turns away his ears from hearing the law, even his prayers is an abomination. Whoever misleads the upright into an evil way will fall into his own pit,
Mhm.
but the blameless will have a godly inheritance. A rich man is wise in his own eyes, but a poor man who has understanding will find him out.
Amen.
That's my reading from Proverbs chapter 28, 1 to 10.
Thank you very much, Mr. Wade.
Thank you
Would you
to,
care to take a 30-second public commentary with
oh
regards to
yes,
safety for the holidays, sir?
thank you.
Thank you.
Thank you, Mr. Chairman. Again,
Yes.
I'd like to take this little opportunity here. The chairman has just give me a little opportunity to do my little public announcement to my people. Be very mindful on the holidays. Um, the holidays is not quite over yet, but again, we've seen too much accidents on the highways. Um, every day, fatalities, and some can say they blame it on the drunk drivers. Some can say they blame it on the deteriorating state of our highways. Some can blame it, well, that person was either texting or, you know, on the phone. But, all these things are a menace to the road users. And sadly, that a lot of times in these fatalities, the drunken driver, like I'll use that, I'll say the drunken driver is the one that survives that accident. You know,
Mm-hmm.
we ask, where is the fairness? And again, I pray that, 2025 brings a closure to a lot of people who awaits closure, um, bring justice, bring a better way of life, and bring prosperity to my people. Um, There are a lot to be desired what's going on in our country, but some profit, some profit of what's going on, and some just gets poor. Again, I call on the authorities to do better. Our people deserve better. Stop the lies, stop the abuse of power, and do the right thing by people and nation. And I pray that the people in the Belize River Valley, again, I keep calling, get some aid, get some help as to their losses because they had suffered and lost a lot. So I hope and pray that the authorities have a heart and help these people and help all those who have been affected and do better in the maintenance of our highways, do better in whatever they are fixing or our infrastructure. There's a lot to be desired, you know, but it seems that no one cares. I call that the authorities for 2025 crack down on price gouging and bring down the price of goods and stop blame it on inflation, stop blame it on the outer world, bring down the price of gas because Belize, in my view and what I've been hearing and seeing, Belize has the highest gas price in the world. Highest, right? So one can believe me or do not believe me. But, you know, the authorities could do better. Um, they fool the people in bringing a 2 cents off the high price, and in 2 weeks' time they raise it 10 times off that 2 cents that they say that they give relief at the gas pump, only for a couple of days, and next week it's back up triple times or quadruple, right? 100 times. So you know, they say they give you 2 cents, but in reality, they know exactly what they're doing. When they raise it, they raise it 60 cents more or 40 cents more. So where who profits, right? They don't care because they carry a fuel out of book where the taxpayers pay for their vehicle. They're moving around, their expenses, their gas, so they don't give a hoot. But I will pass it back over to the chairman. But like I say, my
Thank you.
people, wake up,
Oh,
and smell the coffee, see what's going on around you, and think about doing better, right? Stop doing the same thing over and over and over, because it's not working. Make some changes in your life, right? So anyway, I will pass it back to the chairman. Thank you, Mr. Chairman.
you're welcome, sir, and thank you for the public service commentary. I hope that people take heed and take caution and are mindful of the fact that we're still in the festive season and people are still drinking, going to friends and relatives and other places and bars and wherever not, and still drinking. And I hope somehow or another that we could be spared of any accidents, at least if people were to be mindful enough, at least in this one instance between now and the New Year's, that we can be spared of any agony or grief, that people can at least know that their relatives are going to be back home with them, enjoying the festivities, and or looking forward to a healthier, happier, and prosperous New Year with God's help. I see our next panelist is in the background. He's already at it himself, so I will not belabor much in terms of what I was about to do to make up some time, but I'll just say that tonight's okay. Before I do that, um, let me just yield back to our next panelist, Gregory, for his introduction before I go forward. Greg,
Good night to the people at home and abroad. Good night,
good night, sir.
Mr. Chairman, and good night,
Good
Mr.
night, sir.
Wade. I want to thank you, the people, for tuning in to this 235th episode of Belizean Affairs. I go back to you, Mr. Chairman.
Thank you very much, sir. And thank you for uh, uh, so, being available tonight to support us in our endeavor. We are looking forward to the new year, but we can't comment too much about it because we're not there yet. We still have a few days left in this year, so we're hoping to grace you with whatever we have left in the tank. We did our public service on our last show. Try to be as nice and as easygoing as possible, and we try to stay out of problems and be positive. But that's not because we don't have things going on that we need to attend to and pay attention to or deal with. So here we go for tonight, being the Friday night program with the constitutional and legal law and case matters uh, overview, review, and or commentaries. I want to go to the Constitution of Belize, Part 1, which deals with the state and the Constitution. Under Part 1, I want to go to Section 2 of the Constitution, subsection 1. And I keep reading this over and over and over because it's critically important for the people of Belize, of home and abroad, Belizeans, to understand the meaning of this one particular statement. And since we have a constitutional group that was supposed to educate us on our constitution, and they have not done enough of a job of it, we on this particular platform have taken it upon our shoulders to dedicate one night a week, at least, to help with that endeavor to educate our people. So we're not doing this because somebody is paying us. We're not getting any of the millions of dollars that the PCC is spending. This is wholly and solely from the heart and minds of some concerned Belizeans. Like the Prime Minister said, we are after him. No, we're not after him. We're after the violation that he and his cabinet and the rest of the government exercise and implement policies of state contrary to what is required by our constitution. That's what we are after. So, Mr. Prime Minister, please be patient with us sometime when we have to cuss you out and tell you things that you don't like here and say it sometime in derogatory ways. It's only just to get your attention, sir. Because we know words alone is not going to help. And if we talk to you nicely, we hope that maybe because we talk to you nicely, you would respond more positively. But unfortunately, we have also learned that that is not the case. So here we go. The Constitution of Belize, Part 1, Section 2, Subsection 1. This Constitution is the supreme law of Belize. And if any other law is inconsistent with this Constitution, that other law, which I will describe later on, shall, to the extent of its inconsistencies, be void. In Belize, we have what is called our Constitution, which I just referred to and read from, and which clarifies unto itself what it is, the supreme law of the land. Why? Because there are other laws. There are procedures, protocols, practices, statutory instruments. There's quite a few different legal methods that is used for the governance of our country. But none of those methods supersede the Constitution of Belize because all those other methods, in order for them to weigh in and have legal standings, they must comply and operate within the bounds of the Constitution. Because if they're made outside of the bounds of the Constitution, as the Constitution says here, and I just read, to the extent of those laws being made either by the House of Representatives or the legislature or by the ministers, by statutory instruments, or any procedures or protocols or practices that any department operates under, for any of those to be constitutional, for any of those to be legal and carry the weight of the law of the country, it's not because the Prime Minister pronounced it, it's not because the legislator pronounced it, it's because the Constitution allows for it. And if any of those laws and practices and procedures are violative, or in other words, violates the Constitution, as it is stated here, they shall be considered as null and void. It is not my words, but the words of the Constitution itself, which is why I read it. I have read it so many times before, and I'll probably keep on reading it, because we know we have these jackals attempting to eviscerate this present Constitution in favor of something different that they want to come up with. But in order for them to do that, they got to commit sedition, and they got to throw out and get rid of this current Constitution, which they cannot get rid of just willy-nilly and or because they desire to do so. Uh, Greg, I would like for you to be ready after I finish read our preamble, which I'm going to attempt to do right now. I'd like for you to see if you can make available for us that presentation that we started with last Friday with, but we had to cut short because of the time. I'd like for that to be played as soon as I finish the preamble, if you don't mind, sir. The preamble of the Belize Constitution reads as follows. Whereas the people of Belize, under paragraph A of the preamble, says, affirm that the nation of Belize shall be founded upon principles which acknowledge the supremacy of God, faith in human rights. Something came in here and it's blocking my view. I can't see the. Okay, now I can do it. Faith in the human rights and fundamental freedoms. The position of the family in a society of free men and free institutions. The dignity of the human person and the equal. Remember that word, equal. It's very critical. It's going to come back quite a few times in our equal and inalienable rights with which all members of the human family are endowed by their Creator. Paragraph B reads as follows. Respect the principles of social justice and therefore believe that the operation of the economic system, that is to say, or patrimony and anything that generates wealth therefrom, must result in the material resources of the community being so distributed as to subserve the common good, that there should be adequate means of livelihood for all, that labor should not be exploited or forced, as was the case where in our the last disaster that we had going through the country, where the employees of the BPO were forced by economic necessity to operate in humane conditions, as in the case of an emergency. but that there should be opportunity for advancement on the basis of uh, recognition of merit, ability, and integrity. That equal protection, remember that word again, equal, it's going to come up quite a few times, not only tonight, but in other presentation we intend to do later on. That equal protection should be given to children regardless of their social status, and that a just system should be ensured to provide for education and health on the basis of equality. That word equal comes up again. Paragraph C reads as follows. Believe, we believe that the will of the people shall, we believe that the will of the people shall form the basis of government, not the will of the elected officials, but the will of the people in a democratic society in which the government is freely elected by universal adult suffrage, and in which all persons may, to the extent of their capacity, play some part in the institutions of national life, and thus develop, develop and maintain due respect for lawful constituted authority. That is, that the lawful constituted authority being then the elected members of parliament, who then, as far as our constitution and as far as our system is concerned, also become the cabinet members who get assented by the Governor General to exercise some of the powers vested in the Governor General. That is, to exercise the power of governance. Paragraph D reads as follows. It's the shortest paragraph in our preamble, by the way. It says, recognize, that is to say, we recognize, we the Belizean people, recognize that men and institutions remain free only when freedom is founded upon respect for morals and spiritual values and upon the rule of law, as compared to what we now have today. This paragraph D is very short, like I said, but it speaks to what ails us today in Belize. That is, that the government wants us, the Belizean people, to abide by the laws, the onerous and unconstitutional and violative laws that they make, none of which binds them to their obligation to serve us, the people, and work on behalf of us, the people, as the government that we elect freely. No, they take all of that, throw it in the trash can, and they turn around and whip us over the head with the very laws that are supposed to protect our own rights. I'll read section D again for emphasis. Please bear with me. We recognize that men and institutions remain free only, don't forget that one single word, only when freedom is fundamental, freedom is founded upon respect for moral and spiritual values and upon the rule of law. You can't have the head lawman committing crimes under the color of law. You can't have his subordinate lawmen them committing crimes under the color of law. You can't have the members of cabinet committing crimes under the color of law. even while in secrecy plotting against the best interests of the country and the people, and then turn around and tell us, well, cabinet decided. Who the hell is cabinet without us? We are the one that delegate the powers to the people that become members of cabinet. So they have no authority or rights to sit in any secrecy meetings to collude against our best interests and well-being, and turn around and say, well, that they have to expend our treasury and resources to defend themselves against us because we demand that they comply with the laws. What kind of jackal and hyenas or vultures operate like that? That's not good faith towards the people who give them the power to govern. Oh, man. I'm sorry about that. I'm supposed to be reading paragraph E and then F, which is the end of it. So spare me the agony of taking you through that little rant just now. Let me just try and finish up the reading. There are other things that we need to do as part of the show, and I don't want to be monopolized by commenting before I finish my reading. So let me stay within the bounds of what I'm expected or hoping to do. So I'll just go ahead then and read paragraph E of our preamble. And I'm doing this for educational as well as awareness or acquaintance purposes for those people who don't have a constitution for themselves, those who are not lawyers, because the lawyers are supposed to read and know these things. They're supposed to have copies of these in their offices. I don't know how often they check it, double check it, and apply their legal skills to try and uphold it and help the country and the people to get their rights validated and vindicated. But that's for another discussion. Paragraph E reads as follows. We require policies of state which protect and safeguard the unity, freedom, sovereignty, and territorial integrity of Belize, which eliminate economic and social privileges and disparity amongst the citizens of Belize, whereby race, ethnic, color, creed, disability, or sex, which ensures gender equality, which protects the rights of the individual to life, liberty, basic education, basic health, the right to vote in elections, the right to work, and the pursuit of happiness, which protects the identity, dignity, and social and cultural values of Belize, not the new identity they are trying to foster on us. Including Belize's indigenous people, which preserves the right of the individual to the ownership of property, the ownership of private property, and the right to operate private businesses, which prohibits the exploitation of man by man or by the state, which ensures a just system of social security and welfare, which protects the environment, which promotes international peace, security, and cooperation among nations. The establishment of a just and equitable international economic and social order in the world with respect for international law and treaty obligations in the dealing among nations. I'll read the last paragraph F, which is not too long, and that's the ending of our preamble as written in our Constitution. And before I finish, make that last reading, I would like to comment a short comment to say that I have met some Belizeans, some of them lawyers, by the way, which is unfortunate, and others who have stipulated to me, apparently in their own ignorance, that the preamble is not part of our Constitution. I pity the fools that fall in that category because it means then that they have no knowledge and understanding of what a preamble is. That is to say, the wishes of the people and the power from which the cited parts of the Constitution derives their authority. So how can you have a constitution without a preamble? How can you have a preamble that is not part of a constitution when it is written right within the same cover and the bounds of the Constitution of Belize? But I think some people are just trying to be cute, basically. Or sometimes they try to test your nerves or your knowledge or your sense of security and awareness as to what is it that you think you know or don't know. Or sometimes they just want to bamboozle you because they don't want you to, like in the case of this present constitution, have any fidelity to it, any awareness about it, any allegiance to it, because their whole intention is they say they want to make some changes, but they're already empowered as lawmakers to make some changes. They just can't eviscerate the whole damn thing, which is what they're attempting to do in lieu of a new constitution that will exclude some of the things that are in this present constitution that they cannot get over or get beyond or deal with. Let me read the last paragraph. We, the Belizean people, according to paragraph F, says that we desire that our society shall reflect and enjoy the above mentioned principles, beliefs, and needs, and that their constitution should therefore enshrine and make provisions within the bounds of that constitution for ensuring the achievement of the same in Belize. That is, in the same principles as were outlined, which I have just read from paragraph A to paragraph F. And that is the ending of our preamble. I now wish to ask our panelist, Mr. Gregory Brackett, if we can indulge us in that requested portion of the program.
Thank you, Mr. Chairman. Before I do that, I would like to go to Mr. Wade first for his intake.
Go
Thank
ahead,
you.
Mr. Wade.
Thank you, Greg, and thank you, Mr. Chairman.
You're welcome, sir.
I'll be short. It's a shame to see how how past leaders, some may understand our constitution, some may not. But I think that once you're a leader, and especially in the capacity, for instance, a prime minister or a minister, they should be versed about our constitution so that they do not take advantage of the process of the system. But here in this country, we see from time to time, past and present government, how they abuse our constitution and they try to flush it, they try to wring it out, they try to disregard it, they try to not pay attention to it. They seems like it's no good for them, and these guys do these things and they get away with it. They get away with it, right? When people try to correct them, they say, "Well, you know, you they try to get after them, or you don't know where they talk about, and they try to put you down. They turn you as you're the bad person, publicly and privately. Like you are the bad person. Just trying to tell them, well, Mr. Man, they do the right thing, and you need to do right by the Constitution, and stop abusing it. But you look like the villain, right? Like the bad person. So all I said, Mr. Chairman, is that I just hope and pray that our courts, right, who's supposed to be the guardian of our Constitution. I just hope and pray that they do that. Nothing more or nothing less. Just
Uh,
do the right thing
Mr.
with the
Wade,
Constitution for the country and for its people. Back to you,
I'll
Mr.
come back to you,
Chairman.
sir, but if you allow me just one statement,
I,
and that
I
is
will
to
not
say,
say much more, but go
oh,
ahead.
okay,
No,
okay,
no, I
sir. Thank
pass
you
it
very
back to
much.
you.
Thank you. Uh, you're 100% in order when you make the statement that they're supposed to rule according to our constitution, nothing more, nothing less. It's being asked of them, or it's being required of them, or that they should be doing. That is that stick to the constitution, validate our constitution, stop run roughshod over our constitution, and stop mislead our people, and stop chancing our people. But recently we have noticed some of these new judges that they are bringing from abroad apparently come with some kind of understanding, like what the unelected one in the Senate had always been saying, and in cabinet had always been saying. They give understandings to the members of the Senate, to the members of the House, and to other people. I presume, based on our present experience right now, based on the last couple of high court rulings, that even the judges are given understandings. That is that the
Yeah.
government must prevail, and if there's any constitutional matters, the government must be deferred to, not the Constitution, which is the supreme law of the land, which these judges are supposed to come and validate and uphold. Their contract is contingent on the government paying their contract or dismantling their contract. And in order not to run foul of the government, I am finding out rulings of late that contravenes our constitution. Then who the hell do we go to get our
Mr.
correction?
Chairman,
If we
if
can't come
I
to the court and
may,
have the court rule on our laws according to our own constitution, then where else do we go? If we have to fight the government and the court is not there to under section 20 of our constitution to give us proper judicial review and vindication according to the laws, where else do we have that? The alternative is for our country to become a revolutionary country and people take the law into their hands if they can't get justice. Because that's what the
mi-
Constitution spoke to in the preamble that I just read. In order to get justice, you must have fairness in the system. I yield back, Greg. And before you play that stuff, Greg, I want to read something else quickly, okay? If you don't mind. I yield to you,
Mr.
sir.
Chairman, if I may, sir,
Yes, sir, I yield
with
to you.
your permission, tonight is constitutional night. I know you're doing reading, but I do have some tape that is show and tell that will specify exactly what you're saying without you having to do all that reading.
Uh,
I will ask your permission
before, before,
to
oh, sorry, finish up, sir. Finish up.
I would like your I would like to ask your permission
Mm.
to show and tell from this stage with explanatory as to what the government is doing per the tapes I'm about to play.
Yes, sir. But if you can hold on for a second, Greg, I do need to read this because it's in context with what precedes the information you're going to present to our general public right now. So I need to. I hadn't planned to put it in here, but it's just let me get it. Time is running, no? So just let me. Um, it's the part one of the Constitution, I believe, under the same section that says state and the Constitution, and I want to read about the state itself. Okay, quickly. It's not going to take me too long, so it shouldn't take me too long. One more little adjustment I need to make. Okay, here it goes. Section 1 of the Constitution of Belize, subsection 1 and subsection 2. They're very short. It's less than 100 words, so I'll try and read them quickly and get out of it. Section 1, subsection 1 reads, Belize shall be a sovereign democratic state of Central America in the Caribbean region. Okay? Subsection 2 reads as follows. The Belize, no, not the, but it says, Belize comprises the land and sea areas defined in Schedule 1 to this Constitution, which immediately before independence, before Independence Day, constituted the country of Belize. I just needed was to preface what you was about to play, Greg, hopefully with this citation here, because it's important for our average people in Belize to understand the context of these things, even though they may not have their own constitution to do their own review. What we're talking about here is the Constitution of Belize. But we also have, while the court, in its powers vested in it, can cite other constitutions from other countries as well, is why I read this just now. Yield back to you, Greg. Mr. Brackett.
Thank you, Mr. Brackett.
You're welcome, sir.
The tapes I'm about to play is from Commonwealth Caribbean countries that has the same parliamentary constitution as the United Kingdom. They all run inside one another, and these are the laws that lawyers go to from other countries when they go to trial. I would like to start off by saying we know that the government compulsory took over State Bank from Mr. Feinstein. On this platform, Belizean Affairs, I have stated it over and over that a government has the right to take private land, but they can only do that if it is for public use. This time, our present government is trying to take this private entity for a foreign entity, as in a foreign investor.
Before you go further, Greg, can I add something else that need to be precluded? The government can take private property under eminent domain, and it must, in the taking, the government must get possession of it, and when the government get possession of it, it then belongs first to the government and people of Belize. They can dispose of it legally as well as
When,
illegally, but they can't
sir,
take.
when
I'm
the
sorry.
government
Go ahead. Go ahead.
acquires any private property under eminent domain, it belongs to the people, not the government, as in the
People are
elected ones.
right.
It is being paid by taxpayers' dollars and it
Mm-hmm.
belongs to the people.
Mm-hmm.
In this case, the Prime Minister is compulsory taking over a private entity
Illegally.
for a foreign investment which is unconstitutional. There was a Boeing case in which the past Prime Minister tried the same thing.
And
You
was
had the
smacked down.
taking over of BTL that failed. We have international cases that are precedent in the same parliamentary ruling. And the only way that a government can acquire private land for foreign investors is to amend the Act and place a section in there that says economical development.
As well as there must be
Outside
a
of
law.
that,
There
it
must also be a law in place for that taking to be done legally under our constitution. That's the ruling that was made by
exactly what
Judge.
I'm saying, sir. Had
Yes, sir.
they went and amend the act to
Mm-hmm.
specify
The purpose
that
of that taking.
eminent domain or compulsory takeover can also be done when it comes to economical development for private entity. They had to do that. In this case, taking over of private property for commercial use is unconstitutional and is not considered public use as in the classification as the BPOs as essential services. It
Which
is
is why
unconstitutional and it is not for public use.
which
I
is
go
why
to the
I'm
first
sorry.
tip.
Greg, before. Which is why I stipulated from a long time ago, over and over on this particular platform, that the matter of this of Mr. Feinstein property taking will not be resolved by the court, because these people will not have a court look on that matter and have them lose the case. So what they will do is the bigger company that's trying to get the property is going to suborn Mr. Feinstein, pay him off whatever is it that he wanted in the first place, and just let him move on. And that matter will never be finished. Mr. Feinstein will not stay around long enough or be available long enough for the court to hear that matter. I have said it before, and that's the way it's being worked on and going on.
Let me
I'm sorry, I'm
let
taking up too much of your time. I
let
want to finish.
me let me re-say this. I have said on this platform over and over when it comes to eminent domain and compulsory takeover. I have specified in words certain cases that the government has lost that I said they would lose over and over. In this case, as we see the government acquiring high powered attorney to
Stalling for
try
time.
to get the high court to violate the constitution, it will not work. I
They're
can
stalling for
tell
time.
you this, the judge who is ruling in this matter can only rule on law. And if he violates the Constitution, he can be held accountable and can be debarred. I will say it again. He can only rule on the Constitution, which is the law, and if he rules outside of that,
Null
he
and
can
void.
be held accountable and be debarred. Let's hear the case.
Hello everyone, I am Anuj Nakade and you're watching Live Law. Live Law is an online legal news portal that brings you news from courts all across the country. In order to stay updated, please subscribe to our channel. In today's video, we will be discussing what is widely considered one of the most important cases and precedents in the history of independent India. It is very definitely the longest case proceeding to ever happen in any case in the country. The case was heard by the Supreme Court for a total of 68 days and the judgment in it was delivered on 24th of April 1973. Exactly 50 years ago today on this date. The importance and impact of this judgment is so clear that the Chief Justice of India, D.Y. Chandrachud, announced a webpage dedicated to the judgment that would help researchers across the world to learn more about it. Hence, we at LiveLaw thought it would be good to bring you a detailed understanding of the case because it is a turning point in history that defines us today. Many of our regular viewers may know that when we usually report on a story, we are very specific about the number of judges pronouncing the judgment. The reason for this is twofold. The first is because the Supreme Court is a court of record, which means that every judgment of the Supreme Court that interprets the Constitution is the law of the land. Any case that is similar to that case or has the application of principles mentioned in the case will be similar in the future. Second, because the number of judges that are hearing the case will determine the strength of a judgment. For example, a judgment by a 5-judge bench will be binding on a 3-judge bench of the Supreme Court. The Keshavananda Bharti case is a judgment passed after a 13-judge bench heard it, the largest ever to be comprised in the Supreme Court of India. So what was the issue and why did it need to be heard by 13 judges for 68 days? The answer is a little bit of a history lesson. After independence, since our country had a feudal system, large parcels of land were owned by a few people. The Kerala Land Reforms Act of 1963 was a progressive legislation which restricted the area of land which one can own. Based on the Kerala Land Reforms Act, the government took over the land of such big land owners for the purposes of distribution to the landless people. In other words, the tillers of the land were made the owners of the land. One Edenir Mutt, at the time headed by Swami Keshavananda Bharti, owned one such large area of land and their land was to be taken away under the Land Reforms Act. So, Keshavananda Bharti, a priest and the head of the Edenir Mutt, challenged the constitutionality of the Kerala Land Reforms Act, saying the right to property is a fundamental right and the government cannot take away his property. He also challenged this decision of the government on the basis that the Land Reforms Act infringed on his fundamental right to equality, the right to life, and the right to manage religious affairs. But the issue was slightly more complicated than that. You see, the power to take away the land under these Land Reform Acts was protected by constitutional amendments. The 24th, the 25th, and the 29th Constitutional Amendment to be exact. In our Constitution, Article 368 gives power to the Parliament to amend the Constitution. So for Swami Keshavananda Bharti to succeed in the court, he would have to challenge all 3 of these amendments to the Constitution. Then the question arose, what can be the limitation or what is the extent that these power to amend the Constitution can be exercised by the Parliament? Can the Constitution be amended completely by exercising this power by the Parliament? Before going further, we should get to know these amendments. To start with, the 24th Amendment. Through this amendment to the Constitution, the Parliament gave itself the power to amend any part or any provision of the Constitution. The 25th Amendment Act allowed the Parliament to further curtail the right to property, which was a fundamental right at the time. And most importantly, in relation to the Keshavananda Bharti case, the Parliament introduced the 29th Amendment Act. This act put the Land Reforms Act in the 9th schedule. The effect of this was that the Supreme Court cannot review any laws in the 9th schedule, and so the Supreme Court would not have been able to review the Land Reforms Act either. We urge you to remember the context of the 9th schedule because this small detail will be important later in the video. Since Kerala Land Reforms Act touched upon the right to property which was taken away by the constitutional amendments, Swami Keshavananda Bharti also challenged the constitutional amendments which enabled the Kerala Land Reforms Act to take away the Edenir Mutt's land. The final question before the Supreme Court was whether the Parliament can amend the Constitution to take away the right to property, which was a fundamental right at that point of time. The Supreme Court, in an earlier case, which is popularly known as Golaknath versus State of Punjab, had stated that the fundamental rights of citizens cannot be taken away by way of constitutional amendments by the Parliament. The judgment was delivered by an 11-judge bench. This is why the Supreme Court now had to form a 13-judge bench to hear Keshavananda Bharati versus State of Kerala. More than 100 cases were read before the court during the course of these arguments, which went on for 68 days. Then, the Union government took a stand before the court that the Parliament had the complete and absolute power to amend the Constitution. The issue then became whether there can be a judicial review of Parliament's power to amend the Constitution absolutely. Finally, the court overruled the Golaknath case and held that Parliament has the power to amend even the fundamental rights in the Constitution and upheld the 24th Amendment. But there is a caveat here. What is the extent of power? Is the power unlimited? The court answered this question by saying that the Constitution has something called the basic structure. Basic structure is not defined in the Constitution, but is understood to be the essence of the Constitution. After Keshavananda Bharati, the Supreme Court identified many aspects of the Constitution which is known as the basic structure, such as democracy, the independence of judiciary, secularism, and the principles of equality, etc. That means tomorrow, even if a party has an absolute majority, which means the party with complete control of the Rajya Sabha and the Lok Sabha, cannot amend the basic structure of the democratic character of our country and make it a dictatorial government. That is the basic structure doctrine. The court also later upheld its power to hold a judicial review of all laws, including the laws in the 9th schedule, if they violate the basic structure of the Constitution. This decision was made in another case in 2007, but the application of review of 9th schedule laws was done after 24th of April 1973, the date of the Keshavananda Bharati case. That's all we have for you in this.
Mr. Chairman and people at home and abroad, let me explain this to you all. The government have the right and the eminent domain to take private property. But in doing so, it has to be paid with redress and it has to have public use. A bridge, a road, a hospital, a park, anything that has to do with the public, the citizen of this country has in use to it. And this is specifically why I'm saying the Belizean government will lose this case if it goes to court because they are stepping outside of the Constitution. The Constitution does not give them the right to compulsorily take away private property for foreign entity under eminent domain. I go back to you, Mr. Chairman, before we go to the next step.
Great presentation, Greg. Mr. Wade, would you like to weigh in,
So
if not necessarily from a
I would
legal
like,
perspective, at least
yes.
as an observer to the process? Because what we are
See,
putting out here tonight, we are hoping that you will be able to garner and understand, and therefore, because not everybody is of legal mind or legal trained, you know, but we do need to have people understand some of these mechanics because people won't understand when and how they are being bamboozled. So please, again, I yield back to you, Mr. Wade, for your commentary, sir.
so I always ask the question, who give these guys the power to do the things that they do against our constitution, right? And I always say that who will hold these people accountable for the things that they do? Who, right? Private citizen, um, a group of attorney in the country, to hold these people accountable for the wrong things that they do. Not maybe or shall, the wrong things that they do to us. And they keep doing it. So, like you said there, Mr. Chairman, we yet to have some good judges that will come here and understand our constitution and uphold our constitution and not be compromised. We need that to stop,
Mr.
right?
Wade, Mr.
So
Wade,
it gives me a headache to see these things happen all the time. And these jackals and hyenas, they do it to us and they walk away in the sunset laughing,
Mr. Wade, if
right?
I may, sir,
Who?
in a parliamentary democracy, the constitution is identical. The Indian constitution is
I
identical
understand
to
all that,
Belizean.
Gregory and Mr. Chairman. I understand all that. It's just me. I'm just saying why these people continue to do it. That's the thing. It's against the constitution. It's wrong, but they still do it. What is wrong with us?
They have us, Mr.
Even the
Wade.
best attorneys come and they fight for those wrongdoers, especially plainly prostituting our constitution, doing all these things against our constitution, and these high power attorney in this country defend these crooks and these criminals. That's my thing. Well, anyway,
Greg,
back to you, Mr.
Mr.
Chairman.
Wade, we have to remember, right? This is why they are coming with constitution reform, because they want to get rid of judicial review and all that. And I will prove it, but before I do, I will ask my good cousin to go to section 69.9 and read it for the people at home and abroad. Kindly get that ready. The thing is this, right? Let me play this tape and hear what the Prime Minister said.
They are suing the government. They're taking the government to court for an action that we think that it is within our right or our ability to do as a government. So obviously we'll have to defend our position, so then the government will have to pay for that.
Which means the taxpayers will pay.
Obviously.
Okay, so but if the acquisition goes through, then the taxpayers are paying for an attorney for land that will eventually belong to a private holder.
No, I think what you need to do is to speak to Mr. Feinstein, because he continues to take our lawsuits for everything. And we have a responsibility to defend. If we do not put anybody and then we lose the case, then what? One, it will set a bad precedent. Secondly, I don't think he is within his right, but he just continues to prolong. So we have.
Now
Wow.
imagine
Imagine that.
you don't think that the man is within his right?
a
That's how much he knows about the
constitutional right.
Constitution.
A constitutional
Oh,
right.
man.
You heard our Prime Minister.
The guy doesn't know what the hell he's talking about, and he's still.
He
continuing
will
indulging
lose the
himself
case
in that kind of
regardless
behavior.
And my
because
thing
he
is,
stepped out of bound. When
my
he
thing is,
went and compulsory take it under false pretense, it's called legalized conspiracy. He conspired with a foreign entity to do
Mab,
that. And not
Mab,
only that, had the
Mabsam,
foreign entity deposit money in a bank
Mabsa
under the
mentality.
false pretense of public use. It's unconstitutional.
sad, real sad. That is high treason. You know what kind of a man do that, right? And sadly the taxpayers' dollars, right? He blatantly bastardized the constitution, right, the law, the land, and still have the taxpayers' dollars, paying for him to defend that. Who does that? What kind of a
Oh,
I
man.
just hope and pray that one day that somebody hold this guy accountable, bring him in front of a judge, right, and bring back these same words that comes out of his mouth, so that he could swallow it again, right?
No,
Who does
no,
that to a country and a people? Go ahead. I'm sorry. Just go ahead, Mr. Chairman.
No, Mr. Wade. Let's go to the second part about the Constitution that they want to reform, right?
Uh,
I have said on
Greg?
this medium, yes, I will have you
Greg?
read that, my good
Oh, no, I
cousin.
was just double checking to make sure it wasn't departing from
Okay?
it, no? Go ahead. Go ahead,
I
sir.
have said on this platform before, over and over, about turning the people into sovereign citizens. They cannot get by the basic structure of the Constitution, so they come to the people and they are coming talking about educating you and want to know what you want to take out, but they are not telling you they have
What
no
they want to put
intention
in.
to come to you to see what you want to take out because they only ask the question, did the survey, and the 18 months has passed. Now it's time to wrap it up. But you know the phrase what they will say?
You understand
The
why I use the
people
term
wanted
jackal?
it changed. The people wanted it changed, and I will show you how they
Greg,
want to get
Greg,
around it.
am I not justified to use the term jackal when referring to the behavior of these people?
Nothing far off. You right on the money there, Mr. Chairman. Right on the money. Right.
Can you,
Yeah.
did you find it yet, sir?
Yeah, it's
Can
available.
you read it before we continue?
Uh, Co- Constitution of Belize, Cap 4, Section 69, Subsection 9. And before reading it, I'm going to put it in its own context, okay? This piece of legislation here that's in the Constitution as of right now has already been ruled as unconstitutional at the three levels of our high courts, and it should not be appearing in this document for me to be able to read it as if it was valid and had merits. I'll explain why. Our past Prime Minister, Mr. Barrow, attempted what you'd call a coup d'etat. Okay? He tried to write the powers vested in the courts out of existence by including this particular piece of legislation in our constitution voted on by Congress, which, like I said before, that's why I read in the beginning of this program the supreme law of the land. And if any other law, such as this particular 69.9, which bastardized our law, our constitution, and was intended to give the legislator what you call supreme legislative powers, even above and beyond the rights and the powers of the Constitution vested in the people as a protection for the people against any rogue government, that he and his colleague decided to submit this piece of legislation from out of his
That
cabinet. Wait,
that
from out
is
of his cabinet.
exactly
Wait, but let me, Greg, the people need to know. There's a lot of people out there that don't know what you and I know, my brother. I'm just trying to make sure that the people get a little understanding of what is it that we think we know. And most other lawyers know, and a lot of other Belizeans know. But there's a majority, the masses of our people that have no knowledge and understanding or comprehension or realization about these technical stuff that has bastardized or constitution. And now I have the privilege to be reading it now in public as if it had any validity. It does not. It's unconstitutional and it's null and void and should have been struck out of the Constitution. Watch how long ago the man was dead. In fact, this thing was dealt with 2011, over a decade ago. And now we have the Brazilian government trying to react to this and pretend that it is still valid, and therefore they can go ahead and create a new constitution, which is why they are hiding behind the idea of asking the people to vote for it or to get involved with the PCC. That was the purpose of the PCC Act, to legitimize bastardization of our constitution. But it won't happen while we are still alive, because we'll hold them accountable. and will expose them at every step of the way. I'll go ahead and read the stuff if you would like for me to do that, Mr. Chairman, Mr. Gregory. I'll go ahead and read 69.9. It never used to exist until Mr. Barrow tried to put it in there to bastardize our constitution. But let me, I'm just trying to make it legible enough, no? So I can read it. If it's too small, it gives me difficulty. And if it's too big, then, I got to go from one side to the next of the page in order to. Let me read it. 69.9 reads as follows. For the removal of all doubts, listen to the great orator instructing the courts that for the removal of all doubts, it is hereby declared by Mr. Barrow and his cohorts that the provisions of this section 9 of 69 of section 69 of the Constitution, this section are all inclusive and exhaustive, and there is no other limitation, whether substantive or procedural, on the powers of the National Assembly to alter this Constitution, which is to say, they can remove the separation of powers doctrine, they can remove the fundamental rights, they can do just about anything that they want without even consulting or coming to the people for a plebiscite as is mandated under the Representation of the People's Act. Because only the people have those type of powers. And when the government want to exercise that power, they must come to the people through a plebiscite to get permission to exercise any such power.
That is exactly why, no, I don't want you to read the rest because I have the show and tell.
Go ahead.
That is why they are coming with this constitution reform. That section 69.9 is why our present Prime Minister just said he believed Mr. Feinstein had no right to do what he is doing because everything is exhausted.
Is he crazy or you think we are stupid? One or the other.
But no, let's bring it to the open. People at home and abroad and gentlemen, that is why I keep saying on this platform, when it comes to the Constitution, they are amending it formal and informal. And they are doing more informal than formal, coming up with all these laws. I will show you how they are getting around to doing it. Let's listen.
Friends, this is the very first video of a series of videos that I'm going to do here. These videos will help you understand important principles and methods. So let's get started. Today I am approaching the basic structure doctrine. Now while discussing this topic, two very important articles are Article 13 and Article 368 of the Constitution. Now Article 13 serves as the protector of the fundamental rights, whereas Article 368 holds the power to amend the Constitution. Now when you clash Article 13 with Article 368, some very important questions come before us. Like, can the Constitution be amended by the Parliament? Can the preamble be amended? Can the fundamental rights be amended? And the most important of it all is the amending power of the Parliament exercised under 368 absolute? Are there any restrictions on it? But in the end, you will realize the whole discussion is a tussle for power. The question is, who is supreme? The Supreme Court or the Parliament? So we'll decide what the answer is in the series of events that I'm going to discuss now. Now the first case in this discussion is the Shankari Prasad versus Union of India. The first Constitutional Amendment Act was challenged in this case. Now the first Amendment Act, amongst other things, is widely known for the abolition of zamindari system. So what happened in this Amendment Act was, there were certain laws that were brought about which were curtailing the right to property. And in order to protect those laws, Article 31A and 31B were inserted in the Constitution. So people started looking at 31A and 31B as an attack on their right to property. So the question arose whether the right to property can be usurped, whether the parliamentarians amend the fundamental rights. The judgment followed that Article 13 Clause 2, which is a protector of the fundamental rights, the word law in it only means law in ordinary sense. That is, when law is made exercising the legislative power and not constituent authority. Therefore, Article 368 includes the power to amend the fundamental rights. Now, the next case in this discussion is the Sajjan Singh versus State of Rajasthan. The 17th Amendment Act was challenged. Why? Because it was restricting the powers of the High Court. Now again the discussion started, what can be amended, what cannot be amended. So in this particular case, they took a view of the earlier case, that is the Shankari Prasad case, and said that the meaning of the words amendment of this constitution under Article 368 meant amendment of any part of the constitution, including fundamental rights. Justice Hidayatullah and Mudholkar had a little difficulty accepting the view that the fundamental rights are nothing fundamental to the constitution. Even they can be amended like other parts of the constitution. In this judgment, it was also said that even if Article 368 did not have the power to amend the fundamental right, the parliamentarians can at any point of time do a suitable amendment and include those powers. So finally, in Sajjan Singh versus State of Rajasthan, it was settled that yes, the whole of the constitution, including the fundamental rights, can be amended. The next case is of Golaknath versus State of Punjab. Again, the 17th Amendment Act was challenged. This time the question was whether the power to amend the fundamental right is unlimited or limited. Now this case is important because an 11-judge bench was constituted. Such a large bench was constituted for the first time. In this case, everything was reversed. The Supreme Court said that the power to amend the constitution, including the fundamental right, is not an unlimited power. It is subject to limitations of judicial review. So this case is important because until now we had a settled position that 368 had an unlimited power. That is, even 13 could not stop 368. But this case reversed the position and said what? No. 368 is subject to limitations of judicial review. The Supreme Court even went ahead and said that Parliament does not have any power to amend or abridge the fundamental right in the way of amendments. Further, the ambit of Article 13 Clause 2 was discussed. They said that the word law used under Article 13 Clause 2 includes amendment, and if any amendment violates fundamental right, it would be void. So you see, up till now there has been a tussle for power, for who's supreme, whether the judiciary is supreme or the parliament is supreme. In the Shankari Prasad case, it was settled that the parliament is supreme. In the Sajjan Singh case, again it was said that the parliament is supreme. But for the first time in the Golaknath versus State of Punjab case, it was said no. Article 368 is subject to limitations imposed under Article 13. So the judiciary is supreme. Now in a movie,
There we go again, sir. We heard who is supreme. This is what the government is doing when it does all those amendments. Now it wants to do constitution reform because it cannot move by the structure of the constitution. And that is why they are coming to the people. I want to pay a little piece to hear what this lady says.
Wait, Greg, don't go there yet. Give me a second. They cannot write out of law the basic structure of the law. In order for a law to exist, there must be a basic structure. So they cannot, as stipulated in many other cases that we have dealt with on this particular platform here, when we deal with the separation of powers and all these things, we cite these things and we say what they are and we clarify them. The legislator cannot one day wake up on whatever side of the bed they wake up, and all 100% of them, including the UVP and the PUP legislators, them decide to collude together at the maximum zenith of the powers of the legislator, all 100% of them, as well as the senators them, all agreeing that they're going to write out the existence of the courts from our basic structure. It cannot be contemplated or countenanced. Because if you ask any one first year law student the question of what is the basic structure, they will tell you, okay, the legislator, the executive, and the judiciary. And none of them can get rid of each other. So the legislature cannot write the judiciary out of existence. Nor can the
in reality,
nor can the legislator write the executive out of existence.
Mr. Chairman, in reality,
The
the separation of power is not the basic structure. The structure of the Constitution is your fundamental right, protected by judicial review. That is what this case came up.
But for you to have a judicial review, you must have a judiciary, which is my point.
That is correct, sir.
So
But
these
it's
guys are
simply
playing fast
saying,
and loose. No, wait. These guys are playing fast and loose and pretending that the legislator, in collusion with the executive, which they are one and the same for all intents and purposes, under this present government and the sizable majority that they have, they feel that they're one entity, when in fact they're two different entities.
right, but listen to me.
Go ahead.
I have said it, right? Listen to this. I've said that the government cannot get by. He has the power to amend the Constitution, right? But he cannot get by the basic structure. So he comes to the people. So he wants to turn you into sovereign citizen. That's what he's doing. Then when he does it, he will say, well, it's the people that wanted it.
Exactly.
Listen to it. Listen.
Friends, this is the very first video of a series of videos that I'm going to do here. These videos will help you understand important principles and methods. So let's get started. Today I'm approaching the basic structure doctrine. Now while discussing
Not the same tape. Listen to this.
There would be, but you must remember there are sometimes judges who are like bulldogs. They'll hold you and they won't let go. What the court is most concerned with, and that's because it concerns them also, is that we are the final interpreters of the Constitution. And if you go against anything to do with judicial review, we will set our face against it. And if that remains, then I see no hesitation in saying that basic structure will also remain.
Like you told us earlier, if you could recall that Justice Chandrachud, coming to the majority in Indira Gandhi in the election case, not because he believed but it was more because he wanted to follow a judicial precedent. And I have always admired that. That's the correct thing to do. You have to admire. You can't stick to your own stupid views which you want to have talked about earlier. And that really changed everything. It was not so much the Khanna verdict in Keshavananda, but the Chandrachud, Matthew, etc. verdict in Rajnarayan, which cemented the doctrine of a basic structure. It actually cemented it for all time. And if you see the 39th Amendment, how ghastly it was. I mean, it is a monstrous, they called it a monstrous amendment. And it was monstrous because it said if it was the election of a prime minister can never be upset by any court at any time, virtually, which was absurd. For, those like me born much after the emergency all of this, what is the basic structure of the Constitution for you?
The basic structure is what ultimately the judges for the time being consider to be the foundation of the Constitution. And it's not who is supreme. You see, this is the wrong question. Of course Parliament is supreme. There's no difficulty. So is the court also supreme. But who is supreme even as regards them, and that's the Constitution is supreme. It's not any group of individuals. It's a document that is supreme. That's put on the highest pedestal. That's a very important thing which most people miss by saying that Parliament is supreme because we are all elected and judges are not elected. That's a usual argument that is put. That makes no sense at all. What is supreme is neither the Supreme Court nor the Parliament. What is supreme is the Constitution. And therefore it's as you want to interpret it. And fortunately, all sane judges, I mean, God willing, they're all sane and they all retire at 65. That's why they retire at 65. So, by and large, I see no hazard to the Constitution as framed.
But going forward, what tenets of the Constitution, what basic features do you see being tested?
You see, first is parliamentary democracy. Suppose you want to convert it into a Hindu religious state. Answer is no. I mean, obvious. I mean, these are obvious things. But nobody wants to convert it. I don't say the government wants to convert it. I'm just saying that these are possible views.
One of the, perhaps the primary reason why we've had 50 continuing years of this doctrine in use is perhaps because the court has used it so sparingly.
That's right. That's my point. And I'm very glad they have used it sparingly. You can't just say whatever you don't like is contrary to. No. Parliament is entitled to change the Constitution. In fact, the Bain case says so. You can change even fundamental rights. No doubt about it. But how you do it, when you do it, why you do it, it all becomes relevant.
Now when the Vice President or the Law Minister say that the basic structure doctrine stands on very shaky legs because it's so vague and amorphous and judged.
Let them introduce whatever they want to introduce and we'll see whether it's a shaky leg or firm leg. That's where the Supreme Court metal will come in. We'll be able to judge what the Supreme Court judges will do. Let's see. And I have full confidence in that they will never permit that doctrine to be watered down.
So there you go, gentlemen. Judges must rule on the Constitution,
which is the supreme law
what
of the land.
it says. So the compulsory takeover is null and void. And that judge cannot alter what the Constitution has in it about compulsory takeover or eminent domain. Period.
Greg,
go ahead, Mr. Chairman.
I wouldn't go that far to say that the judge cannot alter because we have seen that happen 2 times in a row now, for which I'm complaining. And it's likely to happen based on the type of judges that we're seeing and the way they are ruling. It's likely to happen again and again and again, to the point where what we consider to be fundamental rights and or what we consider to be the separation of powers and what we all these things that we who delve into the legal environment and pull these things.
Mr. Chairman,
we are going to be surprised many times over and over.
Mr. Chairman, let me say
one
this.
One last statement. Just like that gentleman just intimated when he said the judges will have the final word and the legislator could continue making all the laws they want, but under judicial review, those laws has to stand muster. And it is the judge's responsibility to decide whether those laws meet the requirements of the Constitution or are violative of the Constitution. So he was correct. He said, just let them go ahead and let them bring the matter to the court and let's see what happens. He is sure. He has one of the most foremost established.
Exactly what I'm saying.
He was sure.
And that is exactly what should happen in this compulsory takeover. It is not for public use, and that is exactly what will happen, as he said.
But remember, he also said about judges, right? That some judges, they wake up on the wrong side of the bed. I mean, not saying exactly
well,
right? But
this would, you know what this would,
which is why you have Supreme Court judges and then above the Supreme Court judges, you have the appellate judges, and above the appellate judges, you have the
Mr.
regional, or
Chairman,
so
this
all these
would
things
be
for that reason.
history in the making. It will be the first stage of the alteration of our Belizean constitution
But these
if
guys want to
this
get rid of the whole
judge
thing.
rules against the constitution,
If
which
what need to
speaks
be,
for
if what
itself.
need to be changed out of the country.
Mr. Wade,
Any judge
Well,
that contemplate that kind of behavior should realize that they need to be chased out
that's
of the country, as far as I'm concerned.
that is a good precedent, and I just would like that judges in a whole, uphold our constitution and do the right thing instead of being compromised, and
Start worrying
like
about the
you
contract.
always say, we
Worry
go
about the contract.
yes, we should put all our faith in the judges, right? And because they will uphold the law, right? So we have seen bad decisions. We have seen that, where they totally throw away the constitution and just, like the good man said, they wake up on the bad side, on the wrong side of the bed, right? And then they do this to us, and then from there they ride out of this country and left us holding a whole bunch of problems, right? But I would like to see, like I say, and I'll take this as for my closing, that the judges in this country that is here now study our constitution and uphold our constitution and do the right thing with our constitution. And please, I would do not want to see them, bastardize it or understanding their assignment, right? I would like for that to change. Back to you, Mr. Chairman. It's your,
You're
and that's
welcome,
all
sir.
I had to say.
We're
We're
at
out
the
of
ending of the
time.
program, but I'd like to turn it over back to Greg for his last legal comments, if he has any.
thank you, Mr. Chairman.
This is a great show, a lovely show tonight.
I would like to
I hope
say,
some of our liars at home and some abroad are paying attention, and I'm sure some of them could learn a thing or two from this particular 235th show of the Belizean Affairs. Kudos to you guys.
thank you,
Go ahead,
Mr.
Greg.
Chairman. For my closing, I would like to say to the people, kindly take some time to read on your constitution for yourself. Don't listen to what these people are saying. Because as someone who knows the constitution and knows constitutional law, I can say this. If the government had good intentions for the people of Belize and wanted to reform the constitution, they would have get learned men and women who knows constitution law so that the citizen can be protected and all their rights would be intact. I would also like to say that because the constitution is enshrined, or fundamental rights is enshrined in it, that if they intend to rewrite the constitution, they must move that over as part of the constitution. And this is why I keep saying the government at this present time has a super majority
Ill will
and they
towards the
can
Belizean
amend
country,
any part of the constitution
except
except the basic structure.
and the
So
fundamental
I don't
rights.
see, the only reason I can see they want to change it is because Section 1(2) is barring them along with Section 20 to make inconsistent law with the Constitution like Section 69(9) and
Which is
Section
bogus.
20, which is judicial review.
Greg,
Back to you, Mr.
before
Chairman.
before we close up, I was going to let you finish closing up right now, but I have the urge to associate that Section 69 that Mr. Barrow tried to pull a fast one on us with the other part of the bogus thing that he tried to pull under Section 2, subsection 2, because for all intents and purposes, this section, got to go a little faster. Just bear with me. I think To close out tonight's wonderful, exceptional session, it will be instructive. I'll use the term instructive since we are attempting to educate our people, and it will be instructive for us to go through this part here. It's not a lot. So, oh, I only have one glass, by the way. Uh-oh, I'm getting in trouble. Okay. Uh, oh, shucks. Okay. What had happened is that Mr. Barrow attempted, like I said earlier, a constitutional coup. He being a senior counsel and one of our preeminent lawyers in the country, as well as prime minister of the country at the time, overreached and tried to power play the process. And for that, the court had to smack him down. Okay? And yet, it would seem like, let me just read the thing. I'll comment on another show on another time. I'll bring up the same thing and comment further then. But just let me read it and get it over with. I read section 2, subsection 1. But the part that in item number 11 of 2011, under the Barrow administration, Mr. Barrow added this section here, which I don't like to read in the first place, because like I said, it's not supposed to be there, and therefore I don't like to give it credence. But I'll just read it for the hell of it, and people need to know. Section 2, subsection 1 is what I read before, and now I'm going to indulge myself against my own best inclination to read subsection 2, which is the bastardized part of the Constitution that Mr. Barrow he put in there, and he was ordered to dispense with it because it was declared null and void, and it is still here. And the Belizean administration is pretending like Mr. Barrow has moved on, so they will make use of this as well. I beg to differ. Not while I'm wrong. It says, subsection 2 says, the words other law as stipulated in our original constitution, when it refers to other law that are violative of the constitution that the Congress would make, and that they should be considered as null and void. He, Mr. Barrow, is now trying to say with his paragraph that in the case of the words other law occurring in subsection 1 above of this section do not include a law to alter any of the provisions of this constitution. Was he sick? Well, I know the man was sick, yes. I shouldn't even ask that as a question. I know he was sick, but not sick in the sense of having a mental sickness. The man had a back problem and some body problem. But the man wasn't sick in the mind to not know that he was violating our constitution bold-facedly. Okay? For which I took him to task quite a bit as well, because as a matter of fact, on that particular day when he was trying to pass some of these things, I went from one side of the house to the other side of the house as an expression of my outright and outrageous state of mind against this particular conduct. Let me read this stuff and finish because it's short and we are on borrowed time right now. As a matter of fact, let me just read the whole thing over since I made commentary, and just read the whole thing over quickly so people can get their own context rather than the context that I'm trying to put it. So section 2 says, the words other law occurring in subsection 1 of this section, which is section 2, does not include a law, or you say any law that the legislator made to alter any of the provisions of this constitution, which is passed by the National Assembly in conformance with section 60, or section 69, which is the part that we had read earlier that he said was not supposed to be there and was violative of the Constitution. So he put in a part in section 69 of the Constitution to go along with this next portion that he put in here as subsection 2 of section 2 of the Constitution, to say that he was then declaring that the legislator would become a supreme legislator, and anything that the supreme legislator writes into law should not be and cannot be questioned and or have a judicial review or changes on. The man was crazy, okay? He was crazy like a fox, because basically what he was trying to do was a coup against our Constitution and the heart of our Constitution, which is to say that our Constitution is the supreme law of the land. The man was trying to eviscerate that part of our Constitution. Where the hell did he come off as a learned person, as a top lawyer, as a prime minister? What was he intending to gain from this bastardization of our Constitution, knowing that at one time or another, PUP would have taken over the reins of the country and would be able to have a field day if this thing was to be allowed to be sustained. We have come to the end of our show for tonight. I would like to thank these good gentlemen, Mr. Gregory Brackett, for all that brings to the table as usual. And I would like to also thank Mr. Wade for his incisive and committed and vigorous attention to these matters. Greg, you did a hell of a good job tonight in terms of what you bring to the table in terms of your legal mind, your experience, the clips that you bring, and like we say, show and tell. Thank you very much. And I think this one is going to be one of those for the archive. I yield back, Greg.
Thank you, Mr. Chairman. With that said, I would like to say good night to the people at home and abroad. And I hope you guys had a wonderful holiday and looking forward to a great new year. Good night.